And I will share my screen. Kim, are you able to see the participant list and let me know if anybody comes to the waiting room?
Mm-hmm.
Terrific, thank you. Okay, well, good afternoon, everybody. My name's Kelly Neighbour. I'm the owner and principal mediator at Kannen Mediation. I also have my practice manager here, Kim Ruslan. Give us a wave, Kim. We have a small audience today. There are quite a few people registered, so I'm assuming they're going to be wanting to watch the recording. But if you have any pressing urgent questions, feel free to interject, but we will have questions and answers at the end of today's presentation. So you can also pop your questions in the chat box if you prefer Kim to read them out. So we're here today to talk about parenting coordination. And I'm going to give you an overview of what parenting coordination is, how it's engaged and ordered in New South Wales. And before we get into the nuts and bolts, I have a disclaimer because I'm fully aware I'm surrounded by lawyers today. Please note that what I'm talking about today does constitute general information. I'm not giving legal advice, and any references should be checked against the Family Law Act. Okay, let's get into it. So today we're going to cover what parenting coordination is, what a parenting coordinator does and what they don't do, suitability and the sort of practitioners you should be looking for, how the process is engaged in New South Wales, drafting process and risk, and then when to refer clients to a parenting coordinator. So we should start, I guess, with a real definition. I'm assuming you've all heard of the term, but you probably haven't seen a precise working definition. So as you can see on the slide, parenting coordination is a child-focused process for the conflict that survives the orders. So that means that parenting coordination is after the orders are made, not instead of them, as opposed to something like FDR. So a working definition is that parenting coordination is a structured, ongoing, and that word probably should be in bold too, a structured, ongoing, child-focused dispute resolution process that helps separated parents who've already got parenting orders or a parenting plan put those arrangements into place. So reducing the day-to-day conflict and keeping families out of court. It's not a substitute for family dispute resolution or mediation. It presupposes that there's something there to implement. So it's about helping parents live that agreement out. So they get their court orders, and you've probably all seen it where your client gets the court orders, and as they're walking out the door, you're going, there's no way in the world they're going to be able to implement those orders. These people are just too high conflict. So, for example, parents with sealed consent orders who still fight every fortnight over changeover time, swaps, kids' soccer. PC is built for exactly that recurring friction. So the problem that parenting coordination addresses is that, you know, high conflict co-parenting, it's a known persistent problem. You can see from the stats here on the screen that almost half of divorces in Australia involve children who are under 18, and approximately 60% of separating couples report ongoing conflict after orders are made, right? So these are the people that are constantly coming back for contravention and variation applications. It's very costly for them. It's congesting the courts. And most importantly, it's really damaging for the children who just continue to be exposed to this continuous conflict, right? So that's the problem that parenting coordination addresses. The moment that you realise that you're dealing with a high conflict couple who are not going to be able to implement orders made, you should consider recommending parenting coordination. Right? You'll identify these high conflict couples really easily. We've all met them. It's the couple who will fight over a changeover location that's a kilometre away from their proposed changeover location. Or they'll fight over who paid for the school shoes last year and who should pay for the backpack this year. Those people. If they can find a way to get at each other, they will. So let's dive a bit deeper into what parenting coordination is and how parenting coordinators like myself can help with these high conflict couples. So first, I wanted to illustrate to you where parenting coordination fits into the ADR landscape. So you all know about FDR, arbitration and litigation. the two most important things to notice here on this table is the timing. I've said it a few times now that it operates after orders are made, when everyone else has gone home. But also the big difference here is about confidentiality. So unlike family dispute resolution, parenting coordination is not confidential. It's reportable. So we'll talk a lot more in a lot more detail a bit later about confidentiality in the second half of the presentation. But yeah, we'll talk about that in more detail shortly. So what does a parenting coordinator do? Well, parenting coordinators come from all sorts of different backgrounds, right? But they usually have either a legal background or a social sciences background. I myself have both. I have a BA Psych and an LLB Laws, and the psychology knowledge is really helpful when you consider the functions of a parenting coordinator, particularly the first function, which is education. So the first thing we do is educate. We want to try and build parents' understanding around the developmental needs of their children at their different ages and how the conflict is impacting on the children. And we want to educate parents about how to be more effective co-parents and how to communicate better, which they're going to need to do to implement the orders they've just been given. The next thing a parenting coordinator does is to facilitate and mediate. So we help the parents resolve those day-to-day disputes that occur as they're trying to implement the orders. And it's very hands-on, and different couples are different. Some couples want you to stay out of it as much as you can and let them come back to you in their coaching sessions and talk things through. Other parents will ring me every weekend and want to tell me about the argument they're having about shoes or changeover locations or whatever. So we facilitate those day-to-day. We don't facilitate them. We assist parents with those day-to-day disputes that arise trying to implement the orders. And one of the other things we do is try to give them tools to go away with. So it's not just about resolving the current issue today. I treat my clients in FDR the same way. It's not just about resolving the issues you're in dispute about now. It's about getting you the tools to make it easier moving forward. The third thing we do is we case manage, right? So we keep the parenting arrangements moving, clarify any ambiguities, the amount of time you spend with a client explaining. They'll have different interpretations of the orders, so I help them read the orders properly and understand what the orders mean and come to an agreement about how they're going to implement it. And finally, there's the monitoring and reporting. So I track compliance with the orders. I make sure everybody's doing what they're supposed to do. And where parents won't cooperate or don't cooperate, I can report those issues to the other parent. I can also report those issues in court if the matter goes back to court. So you can see that a lot of the parenting coordinator's day is spent in the unglamorous parts of dealing with day-to-day arguments and over children's belongings and changeover times, etc. What a coordinator is not. So parenting coordinator is obviously not a judge, not an arbitrator. Those first 2 points here are most important to all you lawyers in the room. We have no judicial power and we can't bind parents the way an arbitrator can, right? Any model that claims a PC decides contested issues runs into the delegation problem, which we're going to talk about in the second part of today. And the PC also does not displace the lawyer's role. Clients still need legal advice. We don't give legal advice. PCs handle the implementation friction, not the legal questions. We're also not a therapist or an investigator, and we're not a forum to relitigate. We're not going to argue about the orders. The orders are in place. We're going to talk about how we implement them. So the confidentiality distinction we touched on before, it's the single most important conceptual difference, right, between family dispute resolution and parenting coordination. So FDR is confidential and largely inadmissible, and that's deliberate. In FDR, you're trying to get people to negotiate openly and freely. So that's the reason why it's confidential and can't be subpoenaed. Parenting coordination, by contrast, is typically established as a non-confidential process by the engagement agreement. So the coordinator can report on whether parents are cooperating and complying. And it's that reportability that gives parenting coordination its teeth. In other words, it's in each parent's best interest to cooperate and engage in the process, because it could be reported back to the court and work against them when new orders are made. So parenting coordination is a good fit where orders or a parenting plan are already in place, recurring disputes are occurring over arrangements, communication breaks down or turns hostile, or the parents that keep returning to you, right? The parents that keep coming back for variation or non-compliance orders. And it's a great fit if both parents can participate safely and voluntarily, but they don't, if there's court orders, obviously they don't need to be coming voluntarily. But one of the things we're really good at is turning those negative clients who don't want to be there, turning them around and getting them interested in the process, because they can start to see the benefit in their own lives and in the lives of their children. If they cooperate, we can try and help them find a better way to move forward. So, sorry, my slide is giving me a hard time here. Okay, so where it's not appropriate, I'm not going to read through the whole list, but you can see the top one, which is probably the most important: unresolved safety risks or family violence. And I just want to touch on this and elaborate a little bit more on this, because the screening point is critical, right? And it's not dissimilar to the screening processes that we use in family dispute resolution. I personally use the DOORS method. And where it's appropriate, I have a shortened version of DOORS because it can be quite long and convoluted. But I'm continuously screening for safety from the very beginning until the very end of my involvement with every couple, right? So if there's, particularly where there's been family violence or accusations of family violence. Now, parenting coordination presupposes a baseline of safety and voluntary participation. Where there are family violence or safety concerns, you would generally say that parenting coordination is perhaps not appropriate. But my issue with that is the same with FDR, right? There's so much out there at the moment with family violence and different levels and different situations. If there's been family violence in a partnership, it doesn't necessarily mean it's now inappropriate for parenting coordination or for FDR, because I think what you screen for is, are they now in a position where they can negotiate freely, right? If I'm screening for domestic violence and I'm screening a couple for appropriateness for FDR or parenting coordination, what I'm looking for is the person that was a victim of family violence still in fear of the other party? Are they going to negotiate freely and openly, or are they going to cave every time the other person gets upset? So I think it's important to recognise that you don't, as soon as you see the words family violence, go, well, they can't go to mediation. That's not how it works. It's just about continuous screening and keeping everybody safe. So when you're looking for a parenting coordinator, you need to know that there are no statutory registration schemes for parenting coordinators in Australia. It's not regulated, right? So your choice of parenting coordinator is a quality control exercise. Some courts do, it's a relatively new thing, parenting coordination. So, but some courts do have a list of known trained PCs and may even order a specific parenting coordinator. But if the choice is left to you, you need to know where to look and what to look for. So specific parenting coordination training is really important. Pick a coordinator who's had the training, because it's a very different skill set. And additionally, you may want to consider professionals who have mediation accreditation with AMDRAS or NEMAS, and ideally FDRP accreditation. So as I said earlier, most PCs have a background in law or social scientists, but a practitioner with both is gold. Sets the girl in the room with both. This also matters evidentially, right? You want a well-qualified coordinator, because their report is going to obviously carry more weight if the matter returns to court. And just out of interest, you might like to know that Relationships Australia actually ran a successful parenting coordination pilot, but unfortunately it was later defunded, so most provision is now private. It may also be useful for you to know, and I'm sure many of you already know, that where there are no orders or agreements for PC, but you really feel your clients need some help, you can find all sorts of interesting and really good workshops through the Relationships Australia website. And also Catholic Care, they run a post-separation co-parenting counselling service. So if you've got those really high conflict people that you want to get them some help, that's where you could refer them to. Getting orders for parenting coordination is obviously the preferred way, especially if there's a likelihood that the judge will order the other party to pay for it. That's always a good thing. And that's more likely if the other party is the more high conflict parent. And also, obviously, if the other parent has the financial capacity to pay for it. So personally, as a lawyer, if I had a client where the other party is clearly the problem, I'd be pushing for orders for parenting coordination because it might just help your client. So how is it engaged and ordered in New South Wales? Practitioners speak loosely of court-ordered parenting coordination, but the Australian legal position is a little more constrained than that. So we'll get into some of the mechanics and some of the limits of parenting coordination. So I guess the limit is that there is no standalone statutory parenting coordination order in Australian family law. They do have it in British Columbia and some of the US states, but we don't have a dedicated to parenting coordination legislation. However, Australian courts are now regularly mandating parenting coordination under Section 13C of the Family Law Act. So courts can order participation in parenting coordination. Obviously, they can't delegate power to the parenting coordinator, which is really unfortunate, but they can't. It's part of the Constitution. But we'll look closer at delegation limits in a moment. The primary pathway is by consent. If you can get both parties to agree to attend parenting coordination, but then get it added to the court orders as a notation, otherwise ask the court to order them. So the general pathway is that the parties would agree, or the preferred pathway, I guess, is that the parties would agree and then it gets recorded in the orders as a notation. There's a separate PC agreement and then the coordination begins. So the key thing, the crucial structural insight here is that there are two documents doing different work. They need to match, but they're two separate documents. There's the orders or the agreement, and then there's the PC engagement agreement. That's where the contract lies with the client. The delegation limit is pretty obvious. Judicial power and parental responsibility can't be contracted out to or delegated to a private coordinator, which is actually a little different to some of the models overseas where a PC can make binding micro decisions. So the practical consequences for drafting: keep the parenting coordination firmly in a facilitative and reporting lane. If you ever find yourself drafting language that lets the coordinator determine a disputed issue with binding effect, you're going down the wrong path. So be careful with the drafting. We should probably mention the 2024 reforms, where the equal shared responsibility presumption was removed, and now require decision-making for long-term issues to be allocated expressly with a revised safety-focused best interest framework. This matters for parenting coordination because those decision-making allocations are exactly what parents argue about day to day. So clearer allocation in the orders gives the coordinator a sharper brief, makes life a little easier. So there's an example here, a sample of a consent order notation. The parties note that they have agreed to engage Kelly Neighbour as parenting coordinator to assist them to implement these orders on the terms of a separate parenting coordination agreement for a period of 12 months. And it can be for a longer period, it can be for a shorter period. Just checking my notes that I haven't missed anything. yeah, okay. So that's just a copy, example of a consent order notation. And then on the right panel, we have that the agreement should address all of those: the scope, the term, the confidentiality, fees, information sharing, and termination and complaint mechanisms. Right. So what does it actually look like? I want to demystify a little what actually happens so that you can set client expectations when you're referring your clients to parenting coordination. The typical shape is this. Intake and screening happens first, where we confirm suitability. Then we have the engagement agreement, which we've just talked about. The coordination sessions are typically around 90 minutes, sometimes 2 hours, depending on the clients. It says here around monthly for up to 12 months. I will often start with a more regular, every week or every fortnight until they get better at dealing with the orders, and then reduce it to once a month and sometimes once every 2 months, depending on how they're going. Then we have the reporting and review, all the way along, obviously, reviewing and reporting where necessary, and then the exit. So that's my favorite part, the exit bit, right? So a good parenting coordination engagement makes itself redundant. That's the plan, right? Parents should need the coordinator less over time, not more. And that's a good thing to tell your client when you're setting them up for PC, because it reassures them that it's just not an open-ended cost that goes on forever. I actually get a little bit like, I've had some orders where people are sent to parenting coordination for 2 years. And I really think, like, unless it's an extreme circumstance, unless you're really dealing with some huge difficulties, I think that's really a bit too long. I think if you can't get these people on track within 12 months to be able to comply with these orders, there's something wrong with the orders, and maybe they need to go back to court. But yeah, I get a bit nervous if a client's still on the books at 12 months. You think, why is this not? You maybe need to change your tactics. So it's about heading off the return to court, right? So think of parenting coordination as a pressure release valve, right, on the contravention variation cycle. For you as lawyers, the value proposition is really concrete. Fewer Division 13A contravention applications and variation applications, lower cost, less delay. And because PC is non-confidential, it's a documented record of who is and isn't cooperating if the matter goes back to court. And so obviously this can change the litigation calculus for a genuinely obstructive co-parent. That's the aim. A little bit on costs, logistics, and risk. As for costs, it's a private fee for service set by the agreement and shared between the parents usually. Sometimes, as I mentioned briefly before, the judge may order one party to pay for all the parenting coordinate, maybe because they recognise that that's the party that's the problem, or maybe they recognise the financial disparity between the parties, and they might tell one party they have to pay all of the costs. My preference is that they both pay something, even if it's not a 50-50 split. I like them both to be contributing something because it just gives them that extra bit of investment into the process. As we spoke about before, the format is roughly a monthly joint session, can be in person or by video. The risk is about the legal privilege. There's no legal privilege, right? And there's no confidentiality. So you need to advise your advise your clients of that, and watch out for conflicts, scope creep, professional indemnity, and complaint mechanisms when you're choosing a coordinator. So when to seek orders? Again, it's about, it's when the orders are fine, but the relationship can't execute them, right? So I would encourage lawyers to screen before referring and choose a properly qualified coordinator. I talked about the safety screening before, but what I would say about when you're choosing your coordinator, make sure that they fit the client, right? So I'm going to, in a little while, I'm going to get Kim to drop the website address into the chat box of Parenting Coordination Australia. And this is where you can go and look at a complete list of PCs that have been trained, and they all have little bios, so you can see where they specialise and where their experience lies. A lot of them do things like, some people specialise in neurodiverse clients, and some people with what do you call it, like really troubled teenagers, or there's all sorts of different specialties. So make sure they've got the appropriate qualifications and they fit the client. And obviously we've talked a little bit already about when to seek the orders. It's obviously when people are going to have trouble implementing the orders. Sealed orders, but constant implementation of fights, a client that's exhausted by all the conflict and the scheduling disputes, and also the ones where you've got, particularly when it's the other party, who are continuously breaching orders or not complying with agreements. So we're getting towards the pointy end now, and the 5 things I would like you to take away from today is that parenting coordination is ongoing, that it's a child-focused process for implementing existing orders. It can also be useful, by the way, for parents who maybe don't have orders. Maybe they've been to mediation and they've got a parenting plan. Those people can, but they have to have something that we can implement. It's a non-confidential and reportable process, and that accountability is its defining feature. Court orders can be made under Section 13C, or parenting coordination can be agreed between the parties in consent orders. A court can't delegate its decision-making to a coordinator, so draft the role as facilitative, not binding. Screen for safety, choose a qualified coordinator, and keep the notation and agreement consistent. So that's the end of me just talking incessantly at you. We have a little bit of time for questions now. If anybody has any questions or thoughts they want to share with the group, please feel free.
Kelly, that was really good. Thank you for that. A question, can you hear me?
Yeah. Yep.
Oh, great. A question, in terms of bringing the child or the children's voices into the discussion, are they able to attend and be involved?
They are able to have their voices brought into the room. We can do that via a child consultant, just like we do in FDRP.
Mm-hmm.
I can interview the children myself if I say, look, I'd really like to capture the thoughts of the children and see how they're coping and what they're feeling, with the consent of both the parents. It's not something I can just say, right, well, I'm going to need to talk to the children. But yeah, if I have their consent,
Absolutely.
they're happy for me to. Yeah, for sure.
That's really good. It's good to know. I've been using a lot of family therapists to play this role, just due to the concern with the reportable nature.
Mm-hmm.
Is there a way, say the agreement, the parenting coordination agreement dealt with the the non-reportable? Can you make it non-reportable, or is it always has to be reportable?
I think if it was just a parenting plan and the parents were coming to me of their own volition, I could probably make it confidential if that's what they wanted. But if it's court ordered, no, because the whole point of it being court ordered is it's the court saying not going to go away until you're told.
Yeah, gotcha. And in terms of what does it look like when the parties are back in court? You've done a report. How does are you then joined as a witness, or do you have to give evidence? Are you subpoenaed to talk to that report?
I can be.
Have you experienced that yet?
No.
Okay.
No. I have to say, just for the sake of transparency, because I don't want to be misleading anybody here, parenting coordination is a really new thing in Australia. It hasn't taken off hugely yet. That's partly why I'm doing the lunch and learn, is to try and get people familiar with it as a concept, because it's a really, really good idea. I haven't done a lot of parenting coordination yet because it's so new. It doesn't get ordered very often in New South Wales. It's more popular in Queensland at the moment. but it's just taking off in New South Wales. So I just want to tell you that up front, because I don't want to sit here and pretend like I do 1,000 coordinations a week. I don't.
That was my next question. No, it wasn't my next question. I
So
wouldn't ask that.
it
I wouldn't
can
ask that
be
question.
subpoenaed as a witness. You can also just be subpoenaed to give an affidavit and a report, not an affidavit, a report of what you've experienced dealing with parents and why they're coming back to court.
And the basis for my question as to whether it can be non-reportable is because when a court orders family therapy and it's non-reportable, it's ordered as non-reportable. So I thought, if that can be non-reportable, well, why can't this also be non-reportable?
Yeah, it's a good question. As I say, being such a new thing, that hasn't really come across my table yet, but I don't know if it could. I guess the court could order it to be non-reportable, but I wouldn't see the point then.
And given what you're saying, that there's no legislative provisions in any act in relation to it, so the essence of any mandated reportable and non-reportable issue is yet to be determined.
I guess so, yeah. As I say, it's all at the moment, I believe it's mandated under Section 13C, which just says that the court has the power to allocate send people to family or other services, it says, family counselling.
Like it does,
So
because as we know,
there's no, when they get specific, and I hope they do make it a specific order section that will say Parenting Coordination Act can be reportable or not reportable, and it can.
That'll be handy because your presentation's been really useful to me. I have a big family law practice. There's about 60 odd family law practitioners in the firm, and so great to hear. And we have a big presence in New South Wales as well.
Excellent. Well, thank you for that feedback.
I'll go and share that with my colleagues, and
and
so hopefully you can help all those families that are needing help in the right direction. So thank you very much.
Oh, it's a pleasure. Thank you for the feedback. I really do. I genuinely believe that I hope it takes off in New South Wales, because I think I know, as I've practiced in family law myself, and I know how frustrating it is when you just know you can make the orders and the orders might seem sound, but they're going to walk away and they're going to be back in a month because they just don't have the skill set. As I said in one of the slides, there are some, I only just recently learned that Catholic Care have a post-separation counselling service, which does a little bit of this. It helps people to understand how to communicate better and implement orders and all that sort of thing. And I try and do a bit of it in my FDRP work as well. But I think Parenting Coordination as its own standalone service is a really good opportunity to change things in the system.
Yeah, absolutely.
I just have a question from Payal. I hope I've pronounced that right.
Yeah.
What are the what is the initiatives that have to be taken to start the parenting coordination, and who can take the initiatives to put parents into the parenting coordination?
If I understand the question correctly, there's two pathways, right? It's either the parents take the initiative, they get advised about parenting coordination and they agree that it would be a good idea for them and they request it. And then they can go onto the parenting coordination website or come directly to me, or they can find a different practitioner and then just make an appointment with them. As long as they've got parenting, at least a parenting plan, if not parenting orders. The other way is that the court orders it. So the initiative would come from one of the lawyers who would recognise that these orders are all well and good, and you would ask the court to make the orders, include in the orders that they have to participate in parenting coordination. I hope I've answered that question properly.
Payal, come back to us. She doesn't have a microphone at the moment, but come back to me if you have further questions on that. Sarah's just stated, thanks for the presentation, and they are utilising parenting coordinators a lot more in matters.
Oh, brilliant.
What state are you in, Sarah? Could you share that with us, just for interest's sake? Victoria. Okay, thank you.
Oh, interesting. That's really good because when I did my PC training, they were saying there was hardly anything in Victoria, hardly anyone in Victoria doing parenting coordination. So that's really good to hear. Thanks, Sarah.
And I've popped that link in there for Parenting Coordination Australia, so you can see a list of PCs available. And you said their bios have a little bit of detail on their specialties also.
Yeah, brilliant.
Thank you.
Any more questions?
No, that's all I have here for
We're running a little
today.
bit ahead of time today, but I know how busy you all are. I don't want to hold everybody up just for the sake of sitting here for an hour listening to me babble. I could talk about this subject all day, but if you don't have any questions, the last thing I wanted to share with you was our contact details and a little bit of information about Kannen Mediation. We provide all sorts of services. We do divorce coaching, family dispute resolution is our biggest thing, and now of course the parenting coordination. So if you need assistance for any of your clients with any of that, please reach out. Thank you very much, everybody, for attending. Kim's got a list of everybody who registered, and we'll be sending out the recording along with a lawyer referral pack that Kim created. The pack includes everything we do here at Kannen and includes a price list and an easy way for you to refer clients. So please take a look at it. And feel free to give me a call or reach out if you want to have a chat about anything. Yes, Kim?
Sorry, I just saw one other question come through from Payal again. I want to ask that in the application of the consent orders or in the proposed orders, as solicitors, can we apply for the parenting coordination orders from the court?
Yes.
Yes.
Please do. Yeah, so have a look at the pack and all my contact info's there. Have a fabulous rest of your week. And I look forward to talking to all of you again soon. Bye for now.
Thanks everyone.
Guys. Bye.
Thanks, Christine. Bye.
Bye.
Bye.